Yes, ladies and gentlemen of the public and press, my name is Representative Paul Ingbretson. I'm the chairman of the Redress of Grievances Committee, newly formed committee that does a constitutional service. We're here to respond to a statement by the Attorney General's office. I'm going to give you a statement, then I'm going to have two other representatives speak to you and two members of the public who are in the petition process. I appreciate your being here. Thank you very much. And I will act as MC and introduce each of the people as they come up. I'm a five-term representative. So this is my statement. It seems important to me to respond to the sensational and I believe irresponsible rhetoric emanating from the Office of the Attorney General regarding the General Court's Redress of Grievance Committee and our activities to produce redress. A surprising number of false claims have been made regarding this legislature and the work of our committee. The Attorney General remarkably seems to actually have a problem with the one provision in our state constitution designed to protect our citizens from government abuse. His comments suggest the actions of an office acting as counsel for state agencies and certainly not as representatives of the people. The New Hampshire Constitution is arguably the most people-friendly, people-protective of all the state constitutions. It says that, quote, all power residing originally in and being derived from the people, all the magistrates and officers of government are their substitutes and agents, and at all times accountable to them. Government, therefore, should be open, accessible, and here we have it, accountable and responsive. The Constitution not only lays out the principle that public officials are the people's servants, but also provides a way to that crucial accountability further down in its two Redress of Grievance articles. Accountability for the wrongs that the people suffer at the hands of government itself is without doubt the purpose of these until recently forgotten articles. Clearly, accountability may be sought through the agencies themselves, perhaps through an ombudsman or the goodwill of agency heads or other officers. It may be sought in the courts, as long as a person's money holds out, but only to the extent that we have not made our public officials immune from litigation. Or it may be sought, in case we couldn't get it anywhere else, through our representatives in the legislature itself, through the constitutionally guaranteed grievance process. That is, we can get redress through the body elected by and therefore closest to the people themselves and responsible for creating our laws and agencies. And also very clear in the Constitution is the word responsive, requiring us as legislators and all those who work for the people to respond when our citizens claim hurt at our hands. How can such a remarkably astute and little people-friendly idea ever be thought outdated, as claimed in at least one recent editorial article? Some argue that in our attempts to give redress, we've taken on quasi-judicial functions that imply a breach of the separation of powers clause, and yet our founders, in their determination to protect us from government abuse, obviously believe in a necessary deviation from that principle. Thus, they limit the separation of powers to what the nature of free government will admit, and I quote, "They wanted no oppression from the people we elect and appoint to our governmental bodies, whose defined purpose was the maintenance of our liberties." To the extent that the courts that the legislature have created and the agencies such as have created such as the family division, or for that matter any civil magistrates, are themselves the source of alleged injury, we must listen, assess the validity of the claims, and attempt to provide redress as appropriate. It was pointed out in one newspaper article that half the petitions come from the family division, the division of children, youth, and families, and the family division of the courts, and that somehow that makes them problematical areas for redress. Complaints involving these two areas are indeed rampant, and for that reason alone should be closely reviewed. However, contrary to claims in the media, the people bringing those petitions have been expressly informed that they will not be getting another bite at a judicial apple. And yet, here are these folks anyway, looking for legislative solutions for the future benefit of their fellow citizens. Another complaint is that we're hearing only one side, that of the aggrieved party. Every single government official named has been expressly invited to state their side, just as this legislature has done in the past. On their behalf, the Attorney General's office claims they can't appear for various reasons, including the issues of confidentiality, claiming that those things tie their hands. We certainly understand that there may be a need to untie their hands in some situations, but the shield of confidentiality must never be used to deny those claiming injury the right to have their claims heard. The Redress of Grievance Committee has tried to make and will continue to seek to improve a process that provides even-handedness and fairness, and we must find a way to enable those involved in the grievances to defend themselves. No determinations have been arrived at in any petitions in which all parties have not had an opportunity to be heard. However, perhaps nothing has been made clearer through our endeavors and the recent spate of unfavorable publicity than that the Office of the Attorney General has an apparent conflict of interest in some of these cases. Whenever citizens claim injury, it's the duty of that office to protect them. However, that same office has a duty to protect the agencies. So, who do they work for when citizens claim injury at the hands of a state agency? Clearly, the widespread attack on a right of citizens suggests a sobering reality of which the patented politicization of that office is a most unfortunate evidence. For that reason, to at least one embattled legislator, it would appear the buck must stop here, with an elected legislature willing and able to obey its constitutional mandate and provide the necessary redress. Finally, if nothing else, though not an actual oversight committee like the U.S. Congress, Redress of Grievances in New Hampshire has already proved to be a lightning rod, a bellwether. It's already exposed systemic and institutional problems and will serve into the future to tell us, your representatives, how to make our government the best it can be for you. Thank you very much. Now I'm going to open the floor. Thank you. Copies of what I said will be made available, so I hope your note-taking wasn't too strained. The next speaker from the floor is going to be Representative Dan Itza of the Constitutional Review Committee Chairman and former member of the Children and Family Law Committee. Without further ado, Representative Itza. Yeah.
Thank you, ladies and gentlemen. The Attorney General has mischaracterized the members of the Committee on Redress of Grievances as antagonistic to state workers. Knowing that the word antagonistic means to stand against, the committee is only antagonistic to state workers that are abusing members of the general public. The idea that the Attorney General might not also be antagonistic to such state workers is at least a little troubling. I spent 10 years on the Children and Family Law Committee, which has a power or duty of overseeing DCYF, and they actually created the Family Court. The practice of addressing grievances through the process of hearing bills has proven itself inadequate, even incompetent, over my period in that committee. The same people would come in time and time again to speak their piece for 5, 10, 15 minutes on bills that were only tangentially related to their grievance. They were, in effect, trying to fit square pegs into round holes. And they got no satisfaction, no relief, not even the idea that they were really being heard. Eventually, they would appear so many times that the committee would regard, on Children and Family Law, would begin to regard them as a nuisance, and they got more frustrated. Redress of grievances is the constitutional process to give sufficient time to understand the problems of people who have in fact been aggressed upon or abused by the government process. To understand the patterns so that we can develop legislative solutions to those patterns of abuse. Instead of trying to make the problems fit the answers that are proposed to the House or the Senate, the Grievance Committee works to develop solutions to the problems that they observe. This is, in fact, the way most legislation was originally introduced, because we listened to the people's problems. You have to ask yourself, who is doing the listening now? Thank you.
Thank you, Representative Itza. I'm going to ask now Representative Cliff Newton, the chairman of Fish and Game, and a petitioner on behalf of 300 Rochester citizens.
I'd like to reiterate what Representative Ingbertson said about Article 8, and also include in there that the public's right of access to governmental proceedings and records shall not be unreasonably restricted. I brought a petition forward on behalf of 300 citizens because the City of Rochester for the last 9 years has had a mayoral appointed comprehensive rezoning committee meet, and they have no records of any of their minutes of their meetings. As a result of their meetings, they brought forth an action item to both the City Council and the Planning Board of a 150-plus page comprehensive rezoning document where they couldn't tell us who made the decisions, what decisions were made, when they were made, who was there for the people. There were public hearings with no records of the public hearings, what input was given. And our rogue City Council was ready to pass this and drive it down the throats of the citizens of Rochester on September 20th of last year. As a result of the petition being brought forward and knowing that they'd have to come to Concord and the citizens would have the right to have their story be told and they would have to respond, it's made a tremendous difference, and I can't thank the Speaker and the committee for doing the things they've done. You do hear both sides. We've had rebuttals. There's been back and forth. Today there'll be another one. So you do get to hear both sides. The onion gets peeled back, and we've actually beginning to understand more and more of what happened, which we wouldn't have been able to had not the threat of coming before this committee happened. One of the biggest things this committee will do is it will remind local governments that we're not a home rule state, that we're an enabling legislation state, and they can't do whatever the heck they want to do, because now there's people watching them, and there's an avenue for the citizens to be heard at a legislative level, which is invaluable. And the committee themselves agreed when they get to hear both sides of the story, they can make a determination. And in this case, they are hearing both sides. There's people coming. There's been approximately 5 or 6 hours of testimony already. So this committee is invaluable. It's done a tremendous service to the City of Rochester. And I will say in 2004, the City of Rochester was admonished for violating the right to know law, and the very same arguments they're using for their defense, they're using now, almost 8 years later. So I would offer that they haven't learned their lesson, and hopefully having to come before redress and grievances will make a difference, so they'll start to get it and realize that the people are the ones in charge and with the power, and the rest of us are their servants. Thank you.
Thank you, Representative Newton. Now, on behalf of the Redress of Grievance Committee, I'm going to ask, surprising him on the spot, the Representative Lambert, George Lambert, to talk about the committee's experience as members of the committee, just briefly.
Many of the committees in Concord if you've witnessed their hearings, bring in people who work for the state in those departments, and they come in, regrettably, as the subject matter experts on topics having to do with, in Department of Health and Human Services, in terms of procedure and other things. And citizens show up, those who consent to be governed show up and get treated as the also appeared in many situations, because there are so many who want to speak, so many voices to be heard, but they're not considered the subject matter experts on the law and government. The Redress of Grievances Committee gives them a seat to be the subject matter experts of those who consent to be governed and believe they have a redress against those who govern them, who theoretically represent them. I've received many phone calls and many thanks for the opportunity of these people to have their voice heard. Even if there's a conclusion that they're wrong, at least there was a way. The first subcommittee that I chaired had a concern where a citizen experienced a situation where a school board chairman was also the chief of police. And they believed that they didn't get a fair hearing when the police department said, "We're sorry, we don't think there's a fair case here." Well, unless someone who was objective went out and said there is no conflict of interest, that appearance of conflict of interest and impropriety is worse than any impropriety that could have happened, because that person was denied a clear, understandable, due process hearing. Redress of Grievances guarantees that citizens who experience that have a place to be heard when everything else fails. It was a fundamental premise of our Constitution, and it's a guarantee of the citizens of this state, and it's probably the most exciting thing to happen in this State House in years, because when we stop holding our government and people, representatives included, accountable, the people lose. It's my pleasure to be on this committee, and I really like to thank everyone who has been on the committee, both in terms of hearing testimony and in presenting testimony, to make sure that the government is being responsible to the people of the state of New Hampshire, and I hope we're setting an example for the rest of the nation in terms of accountability. Thank you.
Thank you, Representative Lambert. I'm now going to bring to the attention of the public and the media, through the media, I hope, two petitioners who have been before us, and let them make brief statements about what we've been and what we've meant to them. I first have Representative Joshua Yosef. I'm sorry, I'm not a representative. Petitioner. Take that back.
Petitioner. Thank you. I will say that this entire process and the situation that I've been faced with has encouraged me to participate meaningfully in the governmental process, and specifically by petitioning to this committee. And I'm thankful to the committee members and to the chairman for allowing me to speak, to share my briefly share with you my experience. I'm the divorced father of an 8-year-old boy. I have not seen him until recently for 13 months. Now, to speak to the issue of one-sided hearings and only hearing one side, I'd like to address my experience in the New Hampshire Family Court. The guardian ad litem that was appointed in my case filed a false allegation against me with the Department of Youth, Children, and Families. DCYF later returned a finding of unfounded. The guardian ad litem's findings were unfounded. Yet, the court intervened, taking the guardian ad litem's recommendations, and removed my child from me in an unnoticed hearing. Now, the problem here is that my due process has been denied by the Hooksett Family Division on, at last count, 100 specific instances I have been unable to get any justice in the New Hampshire Family Division whatsoever. To me, it's very troubling to me as a father, but as a citizen, it's even more troubling because I'm sure that I'm speaking on behalf of hundreds, if not thousands, of similarly aggrieved individuals that have endured.
You are correct, sir. I know many of them.
That have endured unbelievable oppression by a system that is endemically and systemically flawed. I have spent and or sacrificed nearly $500,000 attempting to obtain justice between lost wages, attorney's fees, other costs such as accountants and experts that the court has required. The court has refused to allow me to even see my child without the intervention of a therapist. Yet, no allegations were founded against me whatsoever. I've never been determined to be unfit. And so what we see happening is fit parents, in my case anyways, I'm a fit parent, never adjudicated unfit, that has had my child stripped from me with no reason but an allegation. In my research, I have found that the only and final stop for any justice whatsoever is the Legislative Committee for Redress of Grievance. It's the last stop for liberty. And that's why I put my petition in through my local representative, who has been a delight to work with and has been tremendously helpful to me. I've spoken before the committee on a number of occasions. I've brought my story. The people named in my petition were invited to speak. They didn't show up. They didn't offer a rebuttal to my accusations. So, in closing, I would just like to say that I am very, very thankful to the founding fathers of this state, to the people who had liberty on their forecast, on their radar, and to the Speaker of the House for reinstituting the Committee for Redress of Grievance, and for all of the committee members who have sacrificed their time, their work, what they could be doing with their day, to listen to problems and stories and accounts of wrongs done to people like myself and to many of the other people that I recognize out in the audience right now. And so my thanks goes out to you people, and my heart goes out to all of the people that have been similarly aggrieved. Thank you.
Thank you, Mr. Joseph. And next I have up a person who's recently been involved with the Attorney General's office himself and won in court 3 times, finally at the Supreme Court. And I want to go ahead and allow him to tell you what this process has meant to him. His name is Jeff Frost.
Afternoon. Yes, I'm Redress of Grievance Committee number 18 for 2011. And the first line of a prepared statement kind of says it all. Absolute power and immunity cannot exist in a free society under the rule of law. In my case, multiple constitutional violations started from day one with my actions between the Attorney General's office and the banking department. They snowballed into a war of attrition when both the Attorney General's office and the Attorney General and the banking department ignored multiple warnings of the unconstitutionality of my case. As a former Marine Corps officer who swore to uphold the Constitution of the United States, I never thought I'd be in the position to have to do that and fight for it against my own Attorney General and my own state agencies. It's been, how I even thought about the Redress of Grievance Committee was by the luck of it. I happened to read an article in the Union Leader on the top page about the formation of this committee. And being a bit of a person of history and knowledge of our Constitution, I thought, wow, thank God that the New Hampshire Constitution endowed our house, the people's house, with this power. There is a small number of people crying out to end the New Hampshire Redress of Grievance Committee. Outside of self-preservation, I cannot understand why. The committee is a constitutionally empowered oversight which is the last checks and balance to abusive government against its citizens. It performs a vital function in providing final place for citizens to challenge what they seem like an insurmountable, as the last gentleman just said, mountain of bureaucracy, absolute power, and immunity of the state and its agents. In New Hampshire, there is approximately 250,000 judicial filings a year. And this is the statistics I got off the Supreme Court website for 2008. Plus thousands of regulatory inspections, administrative actions with civil violations, fees, fines from agencies such as the insurance, banking, DRA, DES, security, Securities Department, employment, family services, and many other perfunctory, powerful panels and boards worked by over 15,000 state employees and part-time employees every year. I find it hard to believe that 33 redress committee hearings in 2011 are somehow a waste of time, as we heard from the Attorney General, unneeded in a free society, and somehow unwarranted. It just amazes me when I read that. The truth are, they are a final sounding board for the citizens believing abuse from the state and desperate for fair and ethical treatment from their government. Challenging approximately 1 in 10,000 actions and filings by the state a year, this redress committee, so important, ensures fair treatment and oversight of the 3 branches of government. Can anyone really believe there is flawlessness year in and year out that never reaches the need for review by the People's House of the extreme cases that happen? No agency, no person should be above a little scrutiny when it guarantees an open and healthy review of our public servants and the laws and regulations they enforce. My case isn't over between the state and New Hampshire. The Redress of Grievance Committee, the reason I went to it a year ago was I was trying to stop the abusive process, because the abusive process was going on, as many people saw it, said it was the Gestapo, it was a lynch mob. It was very abusive and very harmful to me, to the citizens of New Hampshire, and maybe even to the United States. Thank you.
I want to just offer you one last point, and that was reminded because of what was just said. We have an effect without passing legislation. We have an effect without trying to fix something. We have a town that had doubled the assessment on a member of their town in a very inordinate way. And when they heard that that petition was being formulated to come before our committee, they corrected post haste. They got a new assessment, and they found an enormous problem, and then they threw out the assessing company they'd been using. So I assure you that what we're doing has ripple effects that are all to the benefit of good government and the future of our wonderful state. Thank you all very much. If there are any questions, I'll take a couple.
What's the status of your process in seeking subpoenas, and has the work of the committees changed at all since the Attorney General's letter?
Well, in answer to the second question, we have seen nothing in the committee, in the Attorney General's letter, that would lead us to see a need for a change. Not a thing. And in fact, as I said before, I would love to have had the Attorney General sit there a couple times with us. I would love to have the press in there a few more times. We have independent press, but I don't see much of the establishment press in New Hampshire there. I apologize. Give me back your first question.
With regard to subpoenas,
The subpoenas, where are we? Well, the way the process works, what was passed through the House was we can request subpoenas. Any committee of the House can now request subpoenas, but we have to go through the Rules Committee. First of all, it's going to have to go through the House. That committee itself has to want it as a majority. Then it has to go through the Rules Committee, again a majority. And then, if the Speaker still doesn't want to see any part of it, it can be eliminated at that point. So we have a pretty good set of checks. But that's where it is. It can be had. Nothing's been done. We are, as we have in the past, as many of you know, formulating questions that are what you might call generic in nature, but very much related. And we're trying to get significant people from the various commissions to come and speak with us, to the departments rather. So, for example, We would like to see someone from DCYF or HHS before us. We would like to see the administrative judge, Edwin Kelly, who receives many, many, many letters, many of which I get copied. And he says, I can do nothing for you, I can do nothing for you, I can do nothing for you. And so we would like to have him come before us and maybe find out just what he can do for people. And therefore where we might want to pick up, because he can't do things if injustice occurs.
That's what I was asking about with regard to the Attorney General's letter. In other words, do you expect these agents of the state to be further stonewalling you as a result of the Attorney General's letter?
Yes, that's a possibility. I would fear that, yeah. And in fact, we've already had previous contacts with some of the agents, some of the individuals in the agencies who immediately, instead of writing back to me, wrote to the Attorney General for protection. So it's a worrisome sight, and I do understand on some levels, especially when we talk about confidentiality, the protection of children. We understand that. We're not lost here. We understand clearly how important that is. I think I had a question over here, and then back to that side.
Mr. Chairman, have you seen the video from June 28, 2011 that shows a Keene, New Hampshire resident being arrested because the presiding justice there, Edward Burke, lies on video camera and lies to his bailiffs?
Yes, I did see that video. Yeah. We're aware of that. One of the things that this committee is doing is collating information. We're trying to find patterns. Obviously, that's a key thing when you're looking at grievances. It wouldn't be unusual to have an incident here, an incident there. We're people. We make mistakes as judges all the way through the line. But if we see patterns, we're worried. So yes, what we're doing is putting the information together as committees. We're formulating. We have a DCYF related subcommittee. We have a DC Family Division subcommittee forming as we speak. And that's what they'll be doing, looking for those kinds of tendencies.
Thank you, Mr. Chairman.
I think over here was next.
3 months ago, the Associated Press reported that the state of Georgia approved a 2,700-person class action lawsuit from people wrongfully incarcerated by the penal court system down there. Do you believe that the Redress Committee here might eliminate some of that here in New Hampshire?
Yes, I believe so. And I think one of the things people think will grow up into is, we'll find tons and tons of horrible problems in work and that sort of thing. And I think what we actually do is we limit it. As I said before regarding the one case, it was a case of something happening and it was quickly fixed. I think we will wind up with maybe a handful or a few hundred even in a couple of years, but I bet it'll start diminishing really fast to the extent that we're effective in hearing what they say and responding. It's definitely in the interest of improved government.
Where do citizens turn to if not to the Redress Committee? Is there other places they can go?
Well, as I said before, they have the courts and they have the agencies themselves, so the ombudsman and things like that. But a lot of people are out of cash. A lot of people are out of money. And these times really lend themselves to the House participating. Over here in the blue shirt.
I just want to say I've been a victim of the family court system. And if I have seen one act of professionalism and the lying and trampling over people, it's unbelievable. There's no accountability. And they know there's no accountability. So they keep doing it and doing it and doing it.
This House believes in accountability 100%. We believe in accountability. Both of us, as the legislature, and in all the agencies that we create, we do believe in that, and we want to promote that. I think one more question, and then I'll close.
Given that some of us have been threatened by lawyers, as in my case, there's a very large connection with lawyers involved in my case. I've been threatened to lose custody of my child, who I've never had less than half custody, and I've had full custody for 2 years. So in the process where my daughter's mother abused her, I ran down to the family court. During that time, lawyers were involved because she worked at the country club and for other lawyers. And I've been systematically removed of most of my assets. And I'd like to know if there's restitution in the slush fund to support all of us who've been taken advantage of.
That's a significant question, and we're working on the answer to it. Thank you all very much.